more people suffering the consequences of this, the pandemic. It's a very difficult scenario. It's very difficult for all of us, especially seniors. There are seniors that still have not had personal contact with their family members because they're in facilities where they're still limiting personal contact or prohibiting personal contact. So it's been very difficult. So how do we plan for something like this? We've gone through it. What things should we consider? What steps should we take to be able to plan for these situations and be up to date on where we should be? For example, there are documents that we can all sign that are very important, that allow members of our family to be able to handle our affairs if the time comes where we're no longer able to handle the affairs. That time could be because of a physical incapacity, or could be because of cognitive deficits, right? Where you're having psychiatric issues, you're having neurological issues, you've been diagnosed with dementia, Parkinson's, and a variety of the other illnesses. So the first document you see is a healthcare proxy. It's a medical document, it's a medical directive. Then there's the power of attorney, living will. The HIPAA form is for medical records. There's the burial designation form, and I'm going to discuss all these documents. And then there's the last will and testament, a revocable trust, also known as a living trust, and an irrevocable trust. For the purposes of this conversation, we're going to discuss what's called a Medicaid Asset Protection Trust. So what is the healthcare proxy? The healthcare proxy is actually the only document recognized by law in New York State where you can appoint somebody to make medical decisions for you when you are no longer able to make them. So even though you've signed a healthcare proxy and you've appointed your agent to make that decision, and then the question becomes, okay, who's going to be the agent? Is it going to be my spouse? Is it going to be my children? Well, I think what you want to do is whoever you decide to appoint is somebody that you should speak to. You should have a conversation with them about what your wishes are relevant to end-of-life decision-making, because this is where the healthcare proxy comes into play. You're no longer able to make decisions because of a medical or cognitive disability, and now you need somebody to make medical decisions for you. Well, if it's a family member, they should really know what your wishes are about where you want to live, if you can live. For example, some people will say, I never want to go to a nursing home. I want to be taken care of at home. So that would be an important consideration for the healthcare agent to make. Some people will say, you know what? If I'm in a coma or brain dead and it doesn't look I'm going to survive, don't keep me alive by extraordinary measures. Don't put me on life support. Don't put me on a respirator. Now, obviously, treating somebody with COVID and using a respirator is different than treating somebody who has a chronic condition. The likelihood of survival is very limited, and putting that person on a respirator or a ventilator. It's a different scenario. So you want to discuss those issues. You want to have somebody that's responsible and somebody that you have confidence in. And remember, a healthcare proxy cannot appoint two agents at the same time. Only one agent at a time can you appoint. So it's a person that you select and then an alternate to that person, okay? And again, one agent at a time. And no matter how old you are, if you're an adult, you should have a healthcare proxy. And you should think about end-of-life decision-making, because you could be involved in an accident, and it could be a very serious accident, and then somebody is going to need to make that decision for you. Now, if you don't have a healthcare proxy and you're in a hospital, there is a law that allows your closest family members to make medical decisions for you, okay? So, but that is only if you're in a specific type of facility, a hospital. There, the family can make decisions for you, and depending on how close they are to you in terms of their intestacy, their estate, then they can make that decision for you, okay? HIPAA form. What is a HIPAA form? Well, HIPAA is the acronym for the Health Insurance Portability and Accountability Act of 1996. It is a document that allows you to select somebody who can have access to your medical and hospital records. The actual authorization of that individual is also in the healthcare proxy. In the healthcare proxy, it says, I direct my agent to have access to my hospital and medical records under HIPAA. So it's already there. I like to use the separate form and not just have it in the healthcare proxy, because in the separate form, you can also give your agent access to your alcohol, drug abuse, and psychiatric records. So it's a lot broader when you use the separate form, and it's a lot more specific. So I like to use the actual HIPAA form itself. And again, in the healthcare proxy, there is a HIPAA authorization. Very important document. We use it all the time. The next advanced directive is the living will. What is a living will? A living will is not your last will and testament. A living will is a writing, and there's no statute, there's no law in New York that recognizes a living will. A living will allows you to express your intention not to be kept alive by extraordinary measures if you are brain dead or comatose with no hope of recovery. That is the critical factor, right? So brain dead, comatose, no hope of recovery, and now you're basically stating to the world, my intention is not to be kept alive by extraordinary measures. So if it's coming to an end of life decision and you have a living will, it's a way of expressing to the world your decision and to the medical community not to be kept alive by extraordinary measures. Now, it's also important because it kind of supports the healthcare agent. So you have a healthcare agent who knows your wishes about end of life, and now he has to tell the hospital that your decision and your request was not to be kept alive and not to be put on a ventilator. And he then pulls out, or she pulls out, the living will and says, not only did he tell me and state so personally that he didn't want to be kept alive by extraordinary measures, he also has that statement in his living will. Very important document. Everybody should have it. The next advance directive, and perhaps the most important document that you're ever going to sign during your lifetime, is a durable power of attorney. I think this is a critical document, and how it's drafted is very, very important. A lot of seniors do not go to a specialist in elder law or estate planning when they're having their will done. They go to their general practitioner, the fellow or the attorney that did their house closing. And what happens is many times the power of attorney that somebody who doesn't practice in this area is not as thorough and detailed as a power of attorney that, for example, someone who is a certified elder law attorney would create. So my power of attorney is almost 15 pages long. What does the power of attorney do? The power of attorney allows you to appoint somebody to handle your financial affairs, to go to the bank for you, to do banking, to do investment decisions. Technically, the power of attorney is valid from the moment it's signed. A durable power of attorney basically means that once you sign it, it survives your subsequent incapacity. So if I sign a durable power of attorney today, and tomorrow I have a stroke and I can't handle my affairs anymore, that power of attorney will be valid and it will allow my agent to handle my financial affairs. Now, how that power of attorney is drafted and what it contains is very critical. A lot of times, the power of attorney will be significantly lacking in gifting powers. The agent will not have the authority to transfer the principal's assets and to make gifts of the principal's assets to others. And not being able to do that can create significant problems, especially if that individual needs long-term care and needs to get on the Medicaid program, or that individual is somebody that has a large estate and needs to do estate planning and needs to get assets out of their name to reduce the size of their estate for estate tax planning purposes. So having a power of attorney that has gifting provisions in it, it's very important. And many, many times, the standard power of attorney does not have a gift rider, and it doesn't have extensive gifting. So I would suggest to you, if you do have a power of attorney, take it out and look at it and see, does it give broad gifting to my agent? And sometimes you'll see in a power of attorney that was done years ago, there's a letter M. It says, gifting the amount of $10,000 as permitted by the tax law. Well, if somebody needs to do Medicaid planning, being able to gift $10,000 may not cut it, right? And also, the power of attorney may not say who the gifting can be made. Can the principal, the agent, excuse me, allow gifts to be made to themselves? So look at your power of attorney and make sure that it is fairly broadly drafted. That's something that's very important. So what's going on in the world of power of attorney? If you look at the next page to my package, you'll see that the existing power of attorney law that we have now, which will be effective until June 12th of this year, has what's called a statutory gifts rider. So you have the power of attorney, and then all of the gifting that you want the agent to have the authority to do is stated in the statutory gift rider. So all my powers of attorney have a statutory gifts rider unless the client says they don't want it. And that's where we spell out all the broad power of attorney, all the gifting language. As of June 13th, the new power of attorney form is not going to have a statutory gifts rider anymore. So June 13th of this year, a new power of attorney form goes into effect. People that signed a power of attorney before June 13th, they're not impacted by it, right? They don't have to comply with this rule, but going forward, the gifting is going to be in the modification section of the power of attorney, and it's not going to be in the statutory gift rider. And what we try to do is we try to customize the power of attorney to the individual needs of the person that's appointing the agent. So the person that signs the power of attorney and wants to appoint somebody is called the principal, and the person that handles the affairs is called the agent. And you can have more than one agent, and you can state that the agents can act separately or act together. If they're, for example, two agents, two children, I like to have them act together. Why? Because my belief is that by having more than one person as the agent on the power of attorney, that it creates a system of checks and balances, right? If you have two agents and they must act together, then one kid can't run to the bank and empty out the bank account because he needs the signature and authorization of the other child. So think about that when you're drafting a power of attorney. Think about what it is you want your agents to be able to do. So, and then there are general provisions in the power of attorney. Real estate transactions, banking transactions, business operations, estate transactions, starting a lawsuit, defending a lawsuit, handling healthcare billing, purchase, sale of goods, tax matters. These are all the kind of general provisions that are included in the power of attorney. Everything other than gifting, that's an expansion of the stated provisions, it goes in the modification section. So we have a power of attorney that has a modification section and a statutory gifts rider now. As of June 13th, we're going to have a power of attorney with a modification section and no statutory gifts rider. So very important document, critical. It's one of the documents that we rely on to do planning for individuals. I can't tell you how many times during the course of a year that somebody will come to me, generally the wife or the husband, and say, look, my wife has dementia, my husband has dementia, and we need to get money out of their name so that I can get Medicaid for them. And they have these accounts in their name, or we have a house in joint name. And I go and look at the power of attorney and say, you can't do it. You don't have the authority to gift assets to yourself, because the power of attorney was not drafted comprehensively. It was not an expansive power of attorney. It was very limited. And when they don't have the ability to make those gifts and transactions and to move the assets, what's the next choice? Well, if the spouse is not competent, then their only choice is to go to court and ask the court to appoint them the guardian of the spouse and do a guardianship proceeding. It's expensive, it's time consuming. So as you can see, having a properly well-worded and expansive power of attorney comes in to be very valuable. So we have the modification section of, of the power of attorney. And there you would put, for example, trust transactions. You could put create a trust, revoke a trust, amend a trust. In the modification section, we talk about access to safe deposit boxes. We give the agent the authority to hire lawyers, CPAs, investment advisors. We can make statutory elections. We give the agent the authority to do a renunciation, to do a disclaimer. These are things that an agent can do, that an individual who is competent could do them. So the power of attorney says, well, you're not competent anymore, you're not able to handle it, but you shouldn't be punished because you're not able to handle it. So let's give your agent the authority to do it. For example, the agent can exercise the spousal refusal form, sign that. So let's say, for example, we have a husband and wife, and the husband is going into the nursing home. And in order to get the husband Medicaid, the wife needs to do spousal refusal. Well, the power of attorney says that the agent can sign the spousal refusal form, that the agent can complete the Medicaid application, also have access to digital assets and devices. Today, a lot of people have a lot of financial records and assets on their computer. Bitcoin. If you own Bitcoin, that's a digital asset. So giving your agent authority to access your digital accounts and digital assets is very important. And again, this is the language that we put in the power of attorney. Okay, last but not least of the typical standard documents is a last will and testament. One of the common misconceptions about a last will and testament is that if you have a last will and testament, then the people named in the will get the assets that you have. Well, that's not true, right? The last will and testament only controls assets that are in your name alone on your date of death. So if I have an account that says Anthony Ania in trust for Lauren Ania and Michael Ania, when I die, the money goes to the named beneficiaries on the account. Same with a joint account, life insurance policy, IRA, 401k that has named beneficiaries. When you have assets that have named beneficiaries on it, your last will and testament doesn't control that. Your last will and testament only controls the assets that are in your name alone on your date of death. John Smith on the account, nobody else named on the account. So if John Smith dies with $100,000 in a bank account and the only name on it is John Smith, the family can't go to the bank and get the money. In order to get the money, they have to be appointed the executor under the last will and testament of the individual. If they have a last will and testament, that means the will has to go through the probate process. Remember, a will is not valid until it's been accepted into probate by the surrogate's court or the probate court of the county where the individual resided. So just because you have a will, that's not the end of the story. A, it only impacts assets that are in your name alone. And B, in order for the will to be validly recognized as your last will and testament, it has to go through the probate process. Yeah, we'll take a break for one question. Go ahead, yes. Right. Now, let me repeat the question for the people watching on Zoom. If you have an account with designated beneficiaries, is that outside of the realm of the last will and testament? Yes, it is. But that account, if you needed long-term care, if you needed Medicaid, that account would impact your eligibility for Medicaid. So unless it's an IRA, if you have a bank account and you have named beneficiaries on it, and you're a senior who needs long-term care, that account, that bank account will impact your eligibility. So last will and testament, what does it do? It allows you to name the individuals that you want to receive your estate. You can be as specific as you want or as general. You could say, I give 100,000 to X, 100,000 to Y, 100,000 to Z, and then I give whatever else I have left over to ABC. You can give specific items, furniture, jewelry, clothing, car collection, baseball hat collection, baseballs, whatever you have, you can identify in the will. And you can specifically say who's going to receive that. But in order for that will to be valid, it has to go through probate. And what is probate? Well, probate requires that a petition be filed with the surrogate's court and an original will be filed, and that notice or citation be given to the people that would inherit if there was no will. And that opens the door to the possibility of people challenging your will, right? So if you have a last will and testament and it has to go through probate, one of the risks of that is, for example, if you did a plan that was not equal to all your children, the fact that that will has to go through probate allows the possibility that one child or two child could contest your will. So one of the things with probate is it's a court procedure. There are filing fees, right? With the court, it's time consuming. It takes anywhere from 9 months to a year. And 99% of the time, the person who wants to be the executor has to hire an attorney to handle the probate. Okay, so probate, expensive, time consuming, right? But it's still, having a will is important because you can name the beneficiaries, you can name the individuals you want to be the executor of the will. You can state, I don't want this person to get the assets outright. I want the person to get the assets in trust. I want the trust to continue for their life or until a certain age. I want them to get the income from the trust, mandatory or discretionary. I want the principal to be paid mandatory or discretionary. There's a lot of different things that one can do in the will. Is it an important document? Yes. But are there other options that you should consider rather than having the will? Yes. And those other options are trust. And the reason why those other options sometimes are good is because, again, will has to go through the court system. I'll give you an example. If you died in March of 2020, courts were closed and they didn't reopen again until June. So think of all the backup there was with people dying from COVID and other illnesses, right? And now their estates having to be filed. That created a significant backup in the court system. It delayed the probate of individuals' wills for months, right? But if you didn't have a will and you had a trust, you didn't have to go through probate. There's no filing with the court. And we're going to talk about that a little later, okay? So what happens if you die and you don't have a will and you have assets in your name alone? Well, then the laws of intestacy take over. And the laws of intestacy basically allow the individuals who are surviving to get parts of the estate based on how close they are related to the individual. So if I were to die now and I have a wife and 2 kids, my wife would get the first 50,000 plus 50%, and my children would share in the other 50% under the laws of intestacy. And in order to have an intestate procedure, somebody has to file, again, a petition with the court to become the administrator of the estate. Okay? So again, no will, you have to go through the court system if you have assets in your name alone. If you have a will and you have assets in your name alone, again, you have to go through the court system. Time consuming, expensive, and always something can pop up. I'll give you a common scenario. I die and I'm 85 years old and I have a will, and my will leaves everything to my wife. But my wife has dementia, right? What happens now if we have to probate the will? In the probate proceeding, the person, the spouse that has dementia, has to be listed as a person under a disability because of their dementia. The court will appoint a guardian ad litem in the proceeding to represent and protect their interest. Further going to slow down the probate process, the guardian ad litem is going to be paid from the estate and you have to file a report. Again, complexities. Anytime you go through the court system, there are going to be complexities, and there's no way to get around it. How do we solve that? A revocable trust and probate avoidance. So rather than having assets in your name alone, you can have assets in a revocable trust. And think of the revocable trust like this bottle, right? I have a bottle of water. And in a revocable trust, I am the creator of the trust, I'm the grantor, and I can also be the sole trustee. And I take the bottle and I fill it up with my assets. I transfer my house to the name of the revocable trust. I transfer my bank accounts to the name of the revocable trust. And now I control everything that's in the revocable trust in the bottle. It's mine. I can do whatever I want with it. I have full control over it. I am the creator of the trust and I am the sole trustee. In New York, you can do that. When I die, the trust says who's going to get the money, who's going to get my estate. And it also says who's going to be the trustee, the successor trustee. Well, the successor trustee then just takes the money, pays whatever estate bills there are, and distributes the money to the beneficiaries. No need to go to court, no need to file a probate petition, no need to worry about, oh, my husband has dementia, and now the court's going to appoint the guardian ad litem. Very, very hard to challenge a revocable trust because there's no notice given to the beneficiaries. There's no file made with the court. There's no public record. It's all private, right? So within the scope of my privacy, I create a trust, a legal fiction that I control, and I decide how the assets that are in the name of my trust are going to be distributed. So the only work that needs to be done once the trust is created is to retitling of the house and whatever bank accounts you have in the revocable trust, okay? So the revocable trust is you. For income tax purposes, it's you. You still get taxed. It spells out who gets the assets in the revocable trust when you die, and it could spell out under what conditions they get it. A revocable trust does everything that a last will and testament does. And all the tax planning that you can do in a last will and testament, you can do in a revocable living trust. So if I wanted to do a credit shelter trust for purposes of estate tax planning or a disclaimer trust, that can still be done by husband and wife through the irrevocable living trust. Only difference is you've got to retitle the assets. So if I have a bank account that says Anthony J. Ania on it, It's going to now say Anthony J. Ania Revocable Living Trust. My house is going to say the Anthony J. Ania Revocable Living Trust. And now when I die, those assets go automatically to my beneficiaries and don't have to go through the probate process. The other advantage of having a revocable trust and avoiding probate is that if you've received Medicaid benefits, right? Now, whether or not you can receive them depends on what assets you have in the trust. But in New York, Medicaid does not have claims and liens on assets in a revocable trust when you die. They can try to enforce a claim or a lien during your lifetime, but once you die, the revocable trust becomes irrevocable, and it's a non-probate asset, and Medicaid will not have a claim against it. And why is Medicaid important? Well, it's important for a lot of reasons. Because in New York, especially, unless you are eligible for Medicaid, be prepared to spend a lot of money on your care. So a nursing home in Westchester County, unless you have long-term care insurance or you're on Medicaid, is going to run you about $177,000 a year. Some places almost $200,000 a year. If you go to New York City, Long Island, you'll see the amount is even greater, about $191,000. Home care. People say to me, gee, well, home care has got to be a lot cheaper than going to a nursing home. Not necessarily so. I have many clients that are spending anywhere from $8,000 to $12,000 a month for home care. Somewhere about $60,000 a year, if not more. So the cost of care is very expensive in the tri-state area. So how can you limit the cost of the potential care? What steps can you take now? Well, you can make yourself Medicaid eligible by doing Medicaid planning. You can go buy long-term care insurance, but if you're over a certain age, you're not going to be able to get it. If you have any medical conditions, it may be cost prohibitive. So there are a lot of things that go into being able to get long-term care insurance. And there's different types of insurance. There's state certified policies, there are straight long-term care policies, and then there's hybrid policies. And then in terms of when we talk about doing Medicaid planning, we're really focusing on the Medicaid Asset Protection Trust, okay? So let's go into a discussion of the federal requirements for Medicaid eligibility. Because remember something about Medicaid. Medicaid is not Medicare. Medicare you get when you're 65 years of age or older and you've paid into the Social Security system. Medicare is the insurance for health insurance, hospital, pharmaceutical, but Medicare does not pay for a long-term care stay at a nursing home, and it does not pay for home care of any significant amount, right? There's no long-term home care program for Medicare. You may get a nurse to come see you, a visiting nurse for a few hours a day for a few weeks after you've gone into a hospital and spent 3 nights there and needed to get rehab. You can go from the hospital, if you spend 3 nights, to a rehab facility, and Medicare will pay for the first 100 days of that rehab. But after day 21, there is a copay, right? The first 20 days, they pay in full, and day 21, there's a copay of about $180 a day. In order to get Medicaid, you have to be a US citizen or a permanent lawful resident alien. You have to be age 65 or older or disabled as defined by the state's Medicaid provisions. And you have to be a resident of the state and county where the application for Medicaid is made. What's interesting about Medicaid in New York is that in New York, there is no durational residency requirement. You can go on Medicaid even if you just got here from Florida. So if you're living in Florida for the last 20 years and you come to New York, you can apply for Medicaid in New York. All you have to do is show the intent to remain here. If you can express the intent to remain here, then you can get Medicaid. And if you're not capable of expressing that intent, there's a policy called where found. So if you're found in New York because you have dementia and you can't express the intent, you're still going to be able to get Medicaid in New York. Medicaid is what they call a means-tested entitlement program. You just don't get Medicaid because you're 65. You have to meet the financial test. And what is the financial test? So if you're an individual that's single, you're not allowed to have more than $904 per month of income. And if you're in a nursing home, you only get to keep $50 a month of your income. And you're not allowed to have more than $15,900 of savings, and you can go prepay your burial. You can do that as well. So those are the financial tests. If you're single, no more than $904 of income. And if you're single, no more than $15,900 of savings. That savings number does not include your IRA and 401k. Medicaid does not count an IRA or a 401k as an available resource for purposes of Medicaid eligibility. However, Medicaid forces you to take the required minimum distribution from the IRA or 401k, and they count that as part of your monthly income. So if you're getting Medicaid home care, right, and all you have is IRA, you're going to be eligible, but they're going to count your required minimum distribution plus your Social Security plus your pension as part of your income. And if you're getting Medicaid home care, there's a way of getting the home care and still protecting your income. It's called a pooled community trust. If it's a couple that's going to get Medicaid at home, they're not allowed to have more than $1,300 a month of income, and they're not allowed to have more than $23,400 of non-IRA savings. Okay? Now, the other scenario is the community spouse. So if, for example, I'm going to get Medicaid home care, or I'm going to get Medicaid nursing home, my spouse, who's going to be living in the community, is allowed up to $3,259 a month of income and is allowed up to $130,380 of savings. That's what they call the maximum community spouse resource allowance. In New York, they always opt for what the maximum of the statute, the federal statute provides. So if, for example, I was to go into a nursing home and my wife wanted to get Medicaid for me and not have to do spousal refusal, my wife could not have more than $3,259 of income and not have more of $130,000 of savings. My wife could also have the house. The house will not affect eligibility so long as it's below, I think, $900,000 in value. That's the limit. But if my wife has more than those amounts, my wife can say, you know what? I'm going to do spousal refusal. I'm going to say to Medicaid that I refuse to use my income and my savings to support my spouse. So I'm going into the nursing home, Medicaid application is filed. Every monies that we have jointly and my house have been moved to my wife. My wife has all the assets now. All I have is my IRA that has named beneficiaries on it. Medicaid will count the required minimum distribution as part of my IRA. They'll count my Social Security. They'll count my pension, whatever income I have from all sources. The only sources they don't count are Holocaust reparations and Crime Victims Compensation Board monies. So they count every source of income except those two. So now my wife has less than the $3,259, has less than the $130,380, and now she doesn't have to do spousal refusal. But if she has more than those amounts, then she would have to do spousal refusal. And when she does spousal refusal, that triggers Medicaid's right to sue her for the value of the services provided. So, in a lot of cases where there's no planning done, right? They've done no Medicaid planning, husband and wife. If we're able to do it using a power of attorney, or sometimes having to go through a guardianship proceeding, move the assets that are in joint name or the assets that are in one spouse's name to the other spouse that doesn't need Medicaid, and then that spouse applies for Medicaid for their spouse and does spousal refusal. Now Medicaid has the right to sue that spouse for the value of support, the amount of money they spend. And what they spend is about 50 to 60% less than what you would pay if you were going to pay privately for the nursing home. So if I'm going into the nursing home and I had to pay privately, it's going to run me about $170,000 a year. Well, Medicaid doesn't give the nursing home $170,000 a year. They give them about 50% less. So sometimes even less than that. So if they're going to sue me, they can only sue me for what they paid. They can't sue me for the private pay rate, only the amount they pay. Okay? Home care Medicaid is the most popular Medicaid program now. It is not the nursing home program. And Medicaid home care is done now, I would say, out of 100 Medicaid applications that we file in our office, I would say 90 are home care applications. Seniors want to remain home and they want to get care at home, whether it's in their condo, their co-op, their house, their beach house, whatever the case may be, they want to receive care at home. And right now, there's actually a little loophole in the law to allow people to give their assets away and get Medicaid home care. So if you have somebody that needs care with walking, needs assistance with walking, dressing, feeding, bathing, toileting, they can actually give their assets away to their children or to an irrevocable trust and get Medicaid home care now without having a look-back period. They still have to go through the evaluation process, right? And the evaluation process has two steps. The first evaluation is called a conflict-free evaluation, where Medicaid sends out somebody to basically eyeball you to see if you're a person that needs assistance with walking, dressing, feeding, bathing, toileting. And the second evaluation is a much more thorough evaluation. It's what they call a day in the life. They look at you and say, during the course of the day, what kind of care do you need? What assistance do you need? And based on this evaluation, they determine how many hours of care per day you're going to get and per week. So the evaluation is a very critical part of the home care process. But they had passed a law that said, as of October 1st of 2020, there was going to be a 30-month look-back period if you gave away assets and wanted to apply for Medicaid home care. There is a 60-month look-back period for nursing home Medicaid, right? So what is the concept of look-back period? Look-back period is basically, if you give something away and you don't get something back of equivalent value, under Medicaid law, you've made a gift. And that gift disqualifies you from Medicaid unless it's made to certain people, your spouse, blind or disabled child, to a special needs trust, or you've given your house to a caretaker child or a sibling with an equity interest. Those are called exempt transfers, transfers that can be made that create no look back. All other transfers create a look back period, and that look back period is going to impact your eligibility for Medicaid. So for home care, law goes into effect as of October 1 in New York, 30-month look back. But the federal government says, because we are in the pandemic crisis, you cannot change any rules regarding Medicaid eligibility if you're getting federal aid. So they pushed it back, the 30-month look back, to April 1 of this year. Now they've pushed it back to July 1st of this year. And there's rumors that it may be pushed back to the end of this year, December 31st. What does that mean? Well, that means that from the home care perspective, if you have assets that disqualify you from getting Medicaid home care, you have more than $15,900 of non-IRA money. Or you have a house that you want to try to start to protect. You can get those assets out of your name. You can either gift them to your children or loved ones or whomever you want to gift them to, and you could put them in an irrevocable trust, and you will not create a look-back period for home care Medicaid as long as you make the transfer and apply for home care Medicaid before July 1st of this year. So a great window of opportunity for individuals to get Medicaid home care. So I'm not going to spend too much time talking about the evaluation process because it's really going to depend on your condition. The less you can do, the more hours of care you're going to get. And when they come to your house to do the evaluation, and now they're doing a lot of them on Zoom, they're really looking at your ability to bathe. And when they look at your ability to bathe, it's just not walking into the shower. Are you able to wash all the parts of your body on your own? Can you handle your personal hygiene? Do you need assistance with walking? Are you at risk of falling? Dressing? Do you know what clothes to wear that are appropriate for the day? Transferring to the toilet, getting in and out of the bathroom, down on the toilet and up from the toilet. So these are all the things that they look at: eating, bed mobility, when they're doing these evaluations, okay? So they're looking at all these different levels of care that you may need, and the less you can do, the more hours you can get. This is an interesting program. This is the Consumer Directed Assistance Program for Medicaid home care. You don't have to have an aide from an agency provide care to you and be paid for by Medicaid. You can pick a family member. It could be a child, it could be a friend, it could be anybody that you select. It can't be your spouse. It could be anyone other than your spouse can be selected to provide the care for you. So this is a great program. It's called Consumer Directed Personal Assistance Program. And one of the advantages of this program is that now you get to decide who's going to give you the care. And that creates a comfort level. There's a lot of seniors that'll say to me, I'm not too comfortable with having a stranger come into my house and stay into my house. Sometimes there really is no choice. It's something that they have to do. But this gives you the ability to select somebody. Now, that person is not going to get paid, $30 an hour, $25 an hour. They're going to receive anywhere between $15 and $17 an hour for the care. Still not bad, not a bad amount. And the other catch with this program is you have to have backup for the aide, right? So let's say I pick my son, Michael, to be my aide, and Michael's going to take care of me. Well, if Michael's not around, I can't call up Medicaid and say, send somebody else. They're not going to do that. I have to have backup in place. I have to have somebody that's going to be the backup. So I have to select the caregiver, train the caregiver, and also have backup for that caregiver, okay? So let's talk about the Medicaid trust, because that is really, and we talked about the look-back period, we talked about their assessments, and I gave you an idea of what the look-back period is. Nursing home is 5 years look back. Home care, still 30 months, but the law's been pushed back because of the emergency. We did discuss the exempt transfers, right? Transfer to a spouse, blind or disabled child, transfer the house to a caretaker child, transfer to a sibling with an equity interest in the property. Those are all transfers that can be made that do not create a look back, either for home care or nursing home Medicaid. Non-exempt transfers are gifts to family members or friends for purposes of Medicaid eligibility, right? So you could always argue that a gift was made for non-Medicaid planning purposes, but depending on your age and condition and whether or not you ever previously made gifts, it may not work. You can argue it, and it has to be an argument made at a fair hearing. So sometimes I'll give you an example. We'll have a client who'll come in and say, yeah, I did make gifts to my kids. Every year since the age of 70, I would give each of my children $15,000. But I was healthy. I didn't have any health-related problems. I didn't think about Medicaid. I didn't need Medicaid. So in that case, we could argue to Medicaid, hey, these gifts were made for purposes that are not related to Medicaid eligibility. They were doing estate tax planning, and that's why they made those gifts. And generally would bring the children in to testify at the fair hearing as to the reasons why the gifts. If the parent can testify, the parent would come in as well. But any non-exempt transfer is going to create the look-back period. Even if you've done no Medicaid planning and you have the proper power of attorney in place with the broad gifting powers, we can do a Medicaid crisis plan where we can protect 50% of your assets, approximately 50%. So let's say, for example, you did no planning, but you had a great power of attorney that you signed, and you held on to all your money, but now you have to go into the nursing home, and your son or your daughter, or a combination of both of them, are your agent under the power of attorney. And they come to see me, and they have this wonderfully drafted power of attorney. And they say, look, my dad's going into the nursing home next month. On May 1st, he's got to go into a nursing home. What can we do? Are we going to lose all the money he has? The answer is, if the proper power of attorney is in place, we can probably protect about 50%. It's a plan that involves gifting assets and also involves a promissory note. And I'll simplify it for you. Let's say I have $250,000. The agent under the power of attorney, because I'm incompetent, takes $125,000 and gives it to my children. And he takes the other $125,000 and my children borrow the money from me. So there is a gift and there's a loan. The gift is going to create a period of ineligibility for Medicaid, let's say of 10 months. The $125,000 loan plus my income is going to be used to pay the nursing home privately for 10 months. And that's how it works. Think of a loaf of bread, half is gifted, half is borrowed, and at the end of the period of time of the ineligibility that we calculate, you've been able to protect the money that was gifted, okay? But in order to accomplish this, either you have to have a properly drafted power of attorney, or you have to go through the court system and get the court to try to approve it for you. And that's called a crisis plan. When we go to calculate the period of ineligibility on that gift in Westchester County, the amount that we would divide the gift by is $13,206. So we would take $125,000, divide that by $13,206, and that would tell us the period of ineligibility, the length of time that we have to pay privately at the nursing home for. And the penalty period commences on the first of the month following the date of a gift. So if I give money away today, I created an irrevocable Medicaid asset protection trust today, and I funded it today, the period of ineligibility starts on May 1st, the first of the month following the date of the gift. My favorite document that I think is probably one of the best planning documents ever devised, an irrevocable Medicaid asset protection trust. So let's go back to the bottle of water. This bottle of water, the revocable trust, you are the creator and you're the trustee. In the irrevocable trust, you are the creator and somebody else has to be the trustee. You cannot be the creator and the trustee of the irrevocable Medicaid trust. So a common scenario is husband and wife, or the spouse that's alive, creates the trust and they appoint their children to be the trustee. So now I'm going to take my house and I'm going to put it in the trust. The trust says that I, the creator of the trust, have the right to live in the house for the rest of my life. Nobody can rent it or sell it without my permission. So now the irrevocable trust owns my house. I'm living in it, and I have the right to stay there as long as I live, and I get all the tax advantages of living in the house. I get the star exemption. I get the personal residence exclusion if the house is going to be sold. If I'm single, I can exclude $250,000 from capital gains. If I'm married, I can exclude $500,000 from capital gains. Okay? All the advantages of living in the house. Only difference is that I pay you still pay the insurance on the house, but the insurance is in the name of the trust. It doesn't say Mary Smith anymore. It says the Mary Smith Irrevocable Trust. That's the insured. Okay? I can also put liquid assets in the trust, not IRA money, but if I had, for example, a $500,000 house and $500,000 of savings, I could put whatever amount of the savings that I feel comfortable with into the irrevocable trust, and that house and that money after 5 years will be protected. Medicaid will never count the money, right, as an available resource that disqualifies you, and the house will never be an asset against which Medicaid can have a claim. So 5 years, the house would be protected, the money would be protected for nursing home Medicaid. What if I needed the money, right? Can my children give the money back to me? No. There is no invasion of principle for the creator of the trust. You can get the income. The trust can say, if there's income being generated, the children have to give it to you, or they can give it to you at their discretion. If you trust your children, what we do is we give the children the authority to go into the trust and give principal to each other. So if there is a reason that you needed the money, and I'll give you an example. Remember we talked about $500,000 house, $500,000 of savings. So the house is in the trust, and I put $250,000 of savings into the irrevocable trust, and I kept $250 in my name. But I used up the $250. I went traveling, I had a great time, or I had medical problems, and I used up that $250. Well, there's still $250 in the trust. My children can go into the trust, give money to each other, deposit that money in their own bank account, and now they can make a gift to you. They can give you the money back. Okay? So that's the way we get money out of the irrevocable trust, by using the children and this power to invade for each other. Now, you're probably saying to yourself, well, I don't know if I trust my kids, right? Right? You may be thinking, I may not trust them. There is a way that you have what I call the hammer. You have the ability to change your mind as to who the trustees are going to be. You can remove your kids as trustees. So if they do something that you don't like, you can get rid of them. Also, you have a power in the trust to change your mind as to who the ultimate beneficiaries of the trust are going to be. You can change your mind as to who gets the money in the trust and the assets in the trust. So even though you don't have access to the principal, you still have all the power and the leverage. Okay? Very good vehicle. When you die, guess what happens to the assets in the trust? No probate. Don't have to go to court. Trustee takes it, pays any bills. If there's taxes, pays the taxes, sells the asset, and distributes the money. No filings with the court. Okay? Again, another document that avoids probate. And it does more than the revocable trust in that it avoids probate and it protects the assets. When you put assets in the irrevocable trust, you start the 5-year clock running, right? You started that look back period beginning. And that period is now a process of, protecting the asset, right? If you never give away assets, if you always hold on to your non-IRA assets, you are never protecting them. The only way to protect assets is to get them out of your name and create the look back period. In order to protect, you must create the look back, okay? So, are there downsides to the irrevocable trust? Sure. Obviously, you have to be comfortable with giving up control over some of your money. Not all of your money. I've never recommended a client put all their money in the irrevocable trust. In fact, the plan that most of my clients have looks like the following. An irrevocable trust for their house and the money they want to protect. A revocable trust for the assets that they want to keep control over, and then their IRA money. What happens if they have their assets in those 3 pots? Irrevocable, revocable, and IRA. No probate when they die. Everything automatically goes to the beneficiaries, and the family does not have to go through the 9 months to 1 year ordeal of probate. Any other questions, folks? Well, thank you very much. It was a pleasure. Is a question? Sure. Yes, please.
What if you put a house in a irrevocable trust and then you want to sell that house and move somewhere else?
Okay, very good question. There is no problem. Question is, what if you put your house in an irrevocable Medicaid trust and then you want to sell the house? You would tell the trustees, I want the house to be sold. You would arrange with the trustees to get a listing broker. The house would be listed for sale. And when the house is sold, the proceeds of sale are paid to the irrevocable trust and deposited into an account in the name of the irrevocable trust. And now the irrevocable trust can buy you another piece of property to live in. And the protection continues with that new piece of property. And you get all the tax advantages when you go to sell your house. You still get the personal residence exclusion. You can exclude $500,000 from capital gains if you're married, $250,000 from capital gains if you're single. So you still get all of the advantages.
But it would be the trustee.
Exactly. With your,
Have to make that decision.
no, they cannot sell or rent the house.
No, but what I'm saying is, if they don't want to buy another house, you don't have that control.
No, you do, because you can remove them.
Oh, I mean,
That's right. If they don't do what you tell them, you remove them. And you find another trustee that will do it. Yeah. Yeah. Any other questions? Yes.
is it irrevocable trust and the Medicaid Assets Protection Trust, is that synonymous? I mean, they're the same.
There's same thing. For purpose, there's other types of irrevocable trust. For example, there's an irrevocable life insurance trust. There's a qualified personal residence trust. But for purposes of our conversation today, we really focused on the revocable living trust that does not really give you Medicaid asset protection and the irrevocable Medicaid asset protection trust. Okay? I want to, yeah.
How often should people revisit their irrevocable?
A very good question. You know, over the last year, I've had a lot of clients revisit their estate planning because of COVID. I think people should really look at their plans every 4 to 5 years. They should sit down and go look at their wills, their trust, because over a 4 to 5 year period, things may change. You know, you were very close with your brother Jim that you appointed as the executor of the will, but now Jim has moved to Arizona and you barely talk to him now. So, you know, there's a lot of things that you want to look at. Are the beneficiaries that you have in your plan, are they the same people you want to have as beneficiaries now? The people that you named as executors and trustees, are they the same people that you want now? So, you have to look at things as they stand currently. And I think every 4 to 5 years is a good stretch of time, especially when you're in your 70s and 80s. 5 years is a long time at that age. So, I'm getting there, so I know. It feels like it's a long time. So, yes. Well, yes. No. The question was, can somebody say the power of attorney is too old? No. If it's a validly executed power of attorney under the laws at the time it was signed, it has to be recognized, right? Now, one thing that this new law that goes into effect on June 13th does, it really tries to solve the problem of banks rejecting powers of attorney. It now basically creates parameters for the bank to either accept or reject it. They have a time frame, and they have to give a reason for rejecting the power of attorney. And if it was not properly rejected, they can be subject to penalties and fines, et cetera. So that's one of the big advantages of the new power of attorney form. For those of you that are interested, there is a sign-up sheet. I think Celeste has it. And for anybody that attended today's seminar, they're entitled to a free consultation. That's a $500 value. And if you're attending on Zoom as well, and you're a member of this group, you'll also be allowed to have a free consultation as well. Yes, Celeste? Right. Yeah. Yeah, what we do is we ask you to bring, important, not necessarily your original will, but you may want to bring a copy of your will. And also we need a list of your assets. In order to do an effective consultation, we need to know exactly what you own, because we need to know how much you own to see if there's an estate tax issue. We also need to see how assets are titled, right? That's important. It's not good enough to say I have a bank account at Chase worth $500,000, but whose name is in the account? Is it yours, joint with your spouse? Is it in trust for your kids? So that's some of the factors that we look at. We want to know how the assets are held. Okay? Well, thank you very much, and good luck, and stay safe.
Ladies, just one final comment. Thank you so much. I mean, those are topics that are usually hard to process, and you've made it very simple. I mean, if I get it, you've done well. Also, the printed information that you gave us is a tremendous thing for us, gives us food for thought and something as a reference to go back and look at what we have.
Yeah. In addition to that, if you want to read a lot more and get more information, go to my website. I probably have over 100 published articles on my website. I just had an article published by the New York State Bar Association Journal about the new power of attorney form. So if you go to my website, you're going to see a lot of articles on various topics, whether it be Medicaid planning, estate tax planning. You're going to see a lot of that, and you're going to learn a lot from my website.
Well, we certainly learned a lot from you today, and I thank you so much for being so gracious. We loved having you, and I think we're all going to go home and look at what we've got going on. Thank you so much, Mr. Rainier.
Oh, website is www.esslawfirm.com. If you go to the last page of this, you'll see it's on the next page. All right.